Recording in progress. Señores delegados y autoridades cuya presencia realza el Seminario de Derechos
delegates of and members of the leadership of the Inter-American Defense Board, ladies and gentlemen that accompany us personally in the Casa del Soldado in Washington, D.C., ladies and gentlemen that follow us through the Zoom platform or in the YouTube channel of the IADB and of the countries of North America, Central America, the Caribbean, South America, Europe, Africa, Asia, and Oceania. Good morning to you all. I am Colonel Talavera Ceredo from the Army of Brazil, and I'm very satisfied to act as the moderator in this very important seminar organized by the Inter-American Defense Board. The seminar on human rights and the international humanitarian law in military organizations is going to talk about the integration of gender in international humanitarian law and the IDB. And we have more than 12,000 people entering, and representatives of international agencies, government officials, civilian officials, NGOs, and the academia, among other organizations and persons with interest in human rights and in the international humanitarian law. For those that follow us through the Zoom platform or in the YouTube channel of the IADB, we inform the possibility of having simultaneous interpretation from English, Spanish, and Portuguese. Please, we invite you to select the audio channel that you prefer to be able to follow the presentations much better. As a friendly reminder, I inform you that we also have available the Zoom chat platform that can be used for questions and comments. If we request everybody that wants to use this tool to specify in your participation, your name, country, and the institution you represent. When we want to inform the audience in line about the resources that we have, and we want to manifest our expresses thanks to the IADB and to everybody that is following us through these platforms. We have registered that the participation that each one of you is very important for us and a motive of satisfaction for all of us that have participated in the organization of this seminar, with the purpose of taking the maximum advantage of your participation. We would like to propose the following question and to ask all those interested to send their responses. What measures can be adopted to sensitize society, the security forces, and the armed forces on the international humanitarian law and human rights? Once again, we hope to have the collaboration of all of you. What measures can be adopted to sensitize society, the security forces, and the armed forces on the international humanitarian law and human rights? Please, I urge you to send your answers through the platform of this seminar. To continue with the general information about the seminar, we communicate that the seminar is going to be taped and will be in YouTube of the IDB. The certificates of participation will be sent to the email that was informed during the moment of registration. We also have a satisfaction survey that we ask you to fill in to contribute to our continuous improvement process. The seminar will have 5 presentations that will be provided by experts that accepted this invitation very kindly to present their presentations on the issues of human rights and the international humanitarian law. I remind the public the eminent technical and academic of our seminar, and the following presentation should be understood within the international ethics of the freedom of professors, and they don't represent the opinions of the IDB. As you can see on the agenda, we will be accompanied during our encounter by the Ambassador Melo Tibeli, permanent representative of Brazil in the OAS, and Mr. Colonel Jesus Gil of the organization Honor Mujeres, and Licenciada Ana Luisa Cinta Narváez of the Red International Cross, and Dr. Romina Morello from the International Committee of the Red Cross, Dr. Karen Mansin of the Inter-American Commission of Human Rights, and Dr. Najla Nassif Palma from the Public Military of Brazil. All the presentations have approximately 20 minutes for their presentation, at the end of which we will have 15 minutes for questions and answers for the public. For the better development of the event, we'll have a 15-minute break after the third presentation. After these initial considerations, I am satisfied to tell you that we have the collaboration of the His Excellency Ambassador Bellini, the permanent representative of Brazil to the OAS, who, despite not being able to be with us in person due to professional reasons, sent us his expression of the permanent representation of Brazil to the OAS on this seminar in a video. Good morning to all. It is a great satisfaction that I address you on the occasion and opening of the seminar of the IADB on human rights and the international humanitarian law. This seminar has registered a series of conferences, international conferences that the IADB has organized with great success. So I congratulate the command for this. And I would like to highlight the format of this event, that the technology allows to broadcast it a lot to all the militaries in our region. The humanitarian international law, as we all know, has this aspect of war rights, and also tries to protect the persons that do not participate directly or indirectly. As we know, it is a moment in which the images of violence are present and constant in the network. And the universe of the war, we have a lot of examples of a lack of human rights and torture, forced disappearance, cruel treatment of prisoners, and violence against women, among many others. So the aspect of the application of international humanitarian law requires a branch of the law that needs to evolve constantly, together with the problems that we try to remedy. In this sense, we can observe that it also applies to the military cyber operations that can provoke serious damages to the civilian populations, regardless of the field of application of the international law. The metric is simple. It is forbidden to harm intentionally. The conflicts should limit themselves to the combating forces and not cause damages, disproportionate damages and unjustified damages to the civilian population. In 2024, we will celebrate the 75th anniversary of the Geneva Convention and the UN. These conventions were conceived due to the reactions to the violations of human rights during the Second World War. And this is a moment that we have to use as an opportunity to evaluate the efficacy in face of the challenges and the development plan of the war law. So it is with great satisfaction that I would like to reaffirm in front of all of you the commitment of Brazil together to humanitarian international law. We cannot but refer in this context the Decree 11752 promulgated on October 25 last, where the Commission, the National Commission for the discussion on the implementation of international law, and we will try to improve the articulation of the governmental entities to be applied in a better way in Brazil. Also, the discussion of proposals and measures to promote the adhesion of to the protocols of Geneva. Also, representatives of the ministry and representatives of the foreign affairs that presided, and the President of the Republic, the Ministry of Defense and Human Rights, and of the Citizenship, and the Ministry of Justice and Public Security. We're convinced that the work of the Commission, together with the civil society and academia and other stakeholders involved in the subject, will give great value to the discussion of the international humanitarian law in the societies. Brazil commits itself and to the board for the continuous discussion of human rights and humanitarian international law. The different audiences in the Americas will come out of this event enriched and will transform themselves into agents of international law. A good event to all of you. Now, we are going to have the cooperation of a colonel, retired colonel of Spain, Jesus Ignacio Gil, military expert of the UN Women, specialized in gender, peace, and security, with a long track of experience in these topics. The first speaker of today's topic, human rights and international humanitarian law. He is also he's in the organization of ONU Mujeres and has ample experience in these topics, as you can see just reading his curriculum on the screen. Good morning, Colonel Jesus Gil. Can you hear me? Yes, good morning. Can you hear me? Perfectly well. Before your presentation, on behalf of the IADB, we would like to thank you for your continuous collaboration with our seminars. For example, what happened this year in the Seminar for Women for Security. In April, we will have a new presentation of Colonel C that will be very illustrative and advantageous. And I invite you to take the floor and talk about the rights of women in situations of vulnerability. The audience is yours, sir. Thank you very much. Before we share the screen, I want to say good morning to everyone that is present from Bogota, Colombia. It is a pleasure and an honor to be able to participate in this seminar. As was mentioned before, I'm going to focus my presentation on the topic of vulnerabilities of women, or women in a situation of vulnerability, but I'm going to focus it on the topic of what can be done, what the military can do in operations to prevent these things. Some of the slides are going to be in English and some are going to be in Spanish. I hope that we can enjoy them, and I'm going to start right now. So the first thing that I'm going to present is just some words of 2014 of General David Morrison from the Army of Australia. And he participated in this conference, this global conference that took place in London, of the conflict of the sex. And he talked about the armed forces of our countries to be a protector or a perpetrator of the things that were happening during the conflict. This soldier cannot be a spectator that commits any sexual crime. The soldier cannot let go the possibility of defending the victim and to report and stop the person that is committing this crime. And therefore, he cannot look aside. He has to act. We think that the girls and women are more vulnerable, but the reality is that that is not their nature, but the inequalities of gender and the social roles that they have to live in their lives. So to be precise, instead of going and talking about vulnerable populations, we're going to talk about children that are in situation of vulnerability. This situation of vulnerability increase with these windows that we see today here, like age and the ethnicity or religion, or a person with a handicap or living in the rural areas. And so we can say that the vulnerable groups are people under vulnerability can be children, women, minorities, or refugees, or displaced persons, or persons that have a certain disability. So the defenders of human rights, or the sanitary staff, or the humanitarian staff, or the journalists that are the persons under situation of vulnerability. What fundamental basis protects women? Well, the Declaration of Human Rights and also the Convention for the Elimination of All Forms of Discrimination Against Women, the famous CEDAW. And the CEDAW says that women are in situations of vulnerability in these cases when they have a disability, when they pertain to ethnic minority, when they are a lesbian or bisexual woman or a transgender, or when they are in detention or in prison, and when they pertain to a rural or remote area, when they're engaged in prostitution, or when they're trafficking, and when they're a domestic and migrant worker, or when they have HIV. So I show you this table because it is important to realize that women and children don't have the same risks in their security. As we can see in English and Spanish, we have the same maybe, but they're different many times. Women and children have different security risks. So as military, it is important to recognize this because we have to identify what part or what risks each one of these groups has. And within our analysis of gender that we will make for any military activity and for any military operation to prepare any gender annex, we have to consider that the children and women have different security risks for the situation, like where they live, the society in which they are, for the stereotypes that we expect from those people, for the daily activities they have, and the freedom of movement or not freedom of movement that they might have. I leave the table here because it usually calls the attention of everyone. But it is important for you to realize that the risks are different. I'm going to pause for the interpreters. Let's continue. Well, we're going to talk for all the colleagues and all the persons that are present about the situation in Colombia. During the conflict in Colombia, in the years of the conflict, we recognize the registry of victims of Colombia. We had this number of victims, more than 9 million, that are distributed among women and men. These figures are on the screen. The number is not so different because it was 51% men and 48% of women. So we have to have a gender perspective at the moment of analyzing the victims. And we will see this right now. In fact, on this table, we can see in blue the women and in green men. And we can see very clearly that although the figures that we saw before are almost the same, well, for example, the crimes against sex freedom, women suffered much more. But when we talk about lesions, physical lesions, men suffered in 74% and women in 26%. And the same thing when they suffered they died because of anti-personal mines. Men suffered much more than women. So we have to have a real gender perspective when we talk about the situations of insecurity between men and women, like kidnapping was 65 men and 25 women. And we're going to continue. So then, what are the fundamental laws that shelter us, especially from the United Nations? Well, basically, it's the Charter of the United Nations that says that men and women are in a situation of equality, and the human rights shelter both women and men. So let's move to the Charter and the Universal Declaration of Human Rights of the UN that we mentioned, where we say the same thing. We talk about the equal rights of men and women, and of even in times of peace and security. And the Geneva Convention talks about women shall be specially protected against any attack on their honor, against rape and forced prostitution and all indecent assault. And for migrants, this is a document that talks about the rights of women and how we have to protect them from the discrimination, and also how it requests the countries individually that have sheltered themselves under this convention to protect women against any type of discrimination and to be equal in gender issues. And we also have, among many other documents, this declaration of the General Assembly 1974, that is the protection of all women and children in emergencies and armed conflicts. So we can see that any form of repression or inhuman treatment of children and women, especially during military operations or in occupied territories, and I'm going to mention the situation of Ukraine, Russia, and Gaza, Israel. All this has to be taken into account at the moment that we have to participate in an operation of peace. We have to consider all these aspects. Well, basically, we all know what the human rights represent, that they are universal, etc., etc. What one of the important aspects is that all men and all women have the same principles. And we forget this, and we distinguish between men and women. We have to distinguish at the moment of analyzing the safety risk, but the treatment has to be the same. We're going to talk about Resolution 1325. What does it say on women, peace, and security? Well, we know that it is the first resolution of the Council of Security that talks about the disproportionate effects on men and children, and also the essential role of women in the prevention of conflicts and the construction of peace, and the efforts for the reconstruction at every level. It also says that we have to implement totally the international humanitarian law, and I repeat, the situation of Gaza, Israel, or the international rights of women. And it also says in our Resolution 1325 that in peace operations, we need to streamline the gender perspective to all the levels, from the strategic level, operational level, and tactical level. It is important. It asks us to increase the women's role in and to participate in equal form in all the roles, and especially on the terrain when it is we're dealing with the civilian population, and the protection and prevention, and take special measures to protect women and girls from sexual violence and gender violence and sexual violence related to the conflict. We know that Resolution 1325 has 9 additional topics that talks about the prevention of violence against women and children. So you can see the numbers here. I'm not going to go one by one, but you can see that we have to systematically stop the violence against gender, and that one person was appointed specifically for this, and for everything, any violence in the conflict. And this goes for the protection of officials that are specific for women, We request to end with impunity and not to commit any sexual abuse due to a war crime, and to establish the justice and not only strengthen the activities of the military and police components, but also the judiciary has to be strengthened in their capacities to participate and to participate with a gender perspective, to know how to act in this case of sexual violence related to the conflict. So you can see that there is a complete set of resolutions that talk about the prevention of the vulnerable population. Well, when a military person enters into a peace operation, they're going to talk to them about gender and human rights. In human rights, specifically, as you can see on this table, we're going to find different cases and different agendas that sometimes are not connected one with the other, but they are really intimately connected. We have talked about the gender violence in the conflict, sexual abuse, trafficking of persons, children in armed conflicts, domestic violence, etc., etc., etc. So it is very important to consider all the agendas before deployment, especially if you're going to work in human rights or in the gender perspective as advisors of gender or focal points on gender. And what is the gender violence related to the conflict? I'm going to talk more in depth about this because this is happening in Colombia. Sexual abuse, it talks about rape, sexual slavery, forced prostitution, pregnancy, abortion, forced marriages, forced sterilization, and any other form of a sexual crime perpetrated against women, men, girls, or boys. And for what? What are the reasons for this sexual violence? It's not for pleasure. They don't do to enjoy it. They do it, as we saw on the screen, to humiliate, to punish the population, to terrorize them, and to get information, to get money, and for the territorial control. I always say that of the armed groups that executed this sexual violence related to the conflict, do this in such a way that it is more terrorific. Sexual violence is even more terrorific than a bullet. You destroy more families, more people, you destroy more societies, more territories, more population with the sexual violence. And finally, as we always say, it is when it's related to the conflict, it is a war tactic. I'm going to show you here, as part of the report that the Secretary General of the United Nations does every year on sexual violence related to the conflict. This is a comparative table of the situation in Colombia. This is a public report. There's nothing here that is confidential. From 2020 to 2022, there has been an increase, a dramatic increase. Last year, compared to this, there's a 55% increase. We can think that before we were in the situation of COVID, and now no. And so everything that is more than one victim is too much. And the table calls the attention that the number of children is stable. The number of men is more or less stable, although it has increased proportionally every year. The number of girls is more or less stable, but the dramatic increase is in women that suffer sexual violence related to the conflict. And if we see below on the screen, we can see that the Afro-Colombian population that suffered this violence, the number has tripled itself, and the number of indigenous people has doubled itself. So we have to pay much attention, because this violence, sexual violence, is committed by armed violent groups, but also they can be caused by the police or the armed military group. So it is very important when we have training with the police and the military to talk about this, not only because these forces are going to prevent these crimes, but also they can commit them themselves. So we have to be aware of that. On the screen, you can see a type of summary of the national report of this year. Of the 455 cases that I have showed, there is a high percentage of the 2,455 cases that we had last year. And you can see that the children, women and girls suffered in 44%. And that the 12 cases of victims of the LGBTQ come from Colombia. This is very important. And that the peace missions have 8 councils of protection for women. And that we have had 146 cases reported against women and children. It is important to keep in mind that of the 2,466 cases is not the reality. The reality is that there are many more. Victims, especially women, do not report their cases because they fear a double victimization, because they don't trust in the security sector or in the judiciary. And so we have to think that the numbers are much higher, unfortunately. What documents do we have at the United Nations level for peace operations? Well, here we have a document that was published on January 1st, 2020, which is the prevention policy and the response to sexual violence in a conflict. It refers to all the entities that participate in the mission, the head of the mission, to the protectors and advisors of women, and the human rights components, the gender units, etc., and above all to the uniformed components that are applied in this case. And especially if the women protectors have a very important role in coordination and protection. These are advisors of the leadership of the mission, but also give guidelines to all the persons that work in the mission. And they're also going to talk with the parties in conflict every time they can to tell them do not commit these crimes of sexual violence. And they're always advocating with the institutions of the state and the peace mission and everybody that is in front of them on the prevention of sexual violence against women and children. So the document that we have here is the handbook for the prevention and response to conflict-related sexual violence. It is a practical and basic document, especially for the persons that we have on the terrain. And what does it say? It says that our mission is to prevent and protect the persons facing of sexual violence. And we've seen that more than 90% these persons are usually women and children. And another important task is to train all the national actors to address the sexual violence that related with the conflict. We have to keep in mind that we deploy ourselves in a country. The country has the responsibility to guarantee the security of its citizens. And at the United Nations, we can help them, advise them, train them, but we can never undertake their role. And only in the case where there is a situation of a lack of security and that the countries cannot guarantee that security, then we can support them. And how can we support them? Well, the military component and the police component, we can create a protection of security where women, men, and children can feel safe. And our units can also appoint focal points for sexual violence at the highest level and the lowest level and at the platoon level. Why? Because the patrols that are going to take place can find a case like this, and we have to see how the report is. The important thing is to keep in mind that sexual violence related to the conflict is not something that it occurred to me. It's something, as we see in the documents, has been streamlining and cross-cutting through all the military documents, in the strategies of the mission, in the planning processes, in the concept of the mission, in the strategies for the prevention and protection of civilians, in the concepts of the operation, both military and police, and in the operational orders, and also in all the military plans and in the annexes of to the operations, both at the operational level and tactical level, and in the SOPs, the standard operation procedures. And as you can see here, the military cannot say that we don't know what this is. We have to work to cross-cut in all the military documents, everything that has to have with the gender perspective and the protection of civilians, including the prevention of sexual abuse whenever we find it. As you can see, at the end of the document, it says this is not an exhaustive list. It's just a summary of the military documents where we apply the prevention of sexual violence related to the conflict. So this is a table that I wanted to show you because many times the military uniformed people commit mistakes when they find a case of sexual violence, and we try to be too proactive. The military that find a case have to protect the victim and detain or subject the victimizer. And then what we're going to do is to call the police or contact what is called the person protector of women, or the focal point of sexual violence related to the conflict, in order to trespass the victimizer, and so that they know what to do. But the first thing is to protect the woman or child, and then take them to a sanitary institution, provided that we have the permission of the victim and the permission to start any process. Military cannot take the addresses or names of the victims, and we cannot photograph them, and we cannot ask them for the documents at the sanitary institution, and we cannot even keep the name of the aggressor or his ID or documents. This is for the police or these women protectors, and we can take we can gather the date, the profile of the victim, the gender of the victim, age, how many victims there were, what is the profile of the perpetrator, if it's a civilian or if it is state forces, and where this was produced, in what territory, in what population, but not the exact address. That is something for the police. And they have a description of the facts. This is because confidentiality, because if we lose confidentiality, the process loses its vigor. The victims don't want to be re-victimized. They don't want to see their address, name, or face in the press. So we have to follow the processes that have been established to maintain confidentiality. And the police and the protectors of women know what they have to do. Well, very important to call your attention on the behavior of the military component. On the screen, I'm going to show you cases that arose in the press and are open in internet, and many of them happened in the Central African Republic. Cases of military peacekeeping personnel that committed the exploitation and sexual abuse. So this is something that in any training, regardless of the type, we have to highlight it and tell our military men and women, this cannot happen. If someone gives you a package of cookies, and you give it to a woman that has nothing to eat, do not expect to use a person and abuse this person sexually because of this package of cookies. They can only say thank you. We cannot abuse of the civilian population in any case. And the question is why? Why do some peacekeepers rape? Why do they sexually abuse and exploit sexually these persons? This is very important for us and for everyone. We're going to see the second part, and this is the topic related to climate change, and as we say in Colombia, with the situation of natural disasters, how these affect women and children. We're going to start first with girls and sexual exploitation, because when there's a scarcity of food, the first thing that we do is that we tell the girl, even if you're only 12 or 13, you're going to marry this person that triples your age, and then we can get food. This happens a lot, especially when men, which are the ones that in many countries take money home, and then they have to abandon the home to look for a job, and they leave their women and children behind. These women are much more vulnerable to this abuse and to the trafficking of people. Also, the participation of women and children in the climate action. And this in Colombia, the defenders of human rights, especially in the cases of natural disasters, are very vulnerable to threats. And sometimes they're even killed, assassinated, or suffer sexual violence. And in many cases, much more than we can imagine. And who are the people that are more at risk? Women, indigenous women, Afro descendants, women with disabilities, migrants, and women that live in the rural areas or remote areas or in areas where the armed groups pass by. And I wanted to give you some data that are impacting in the analysis of natural disasters that we have in UN Habitat in 141 countries tell us that women suffer disproportionately by disasters. It's almost a summary of the 1325, only that the figure is incredible. It's 14 times more likely to die than a man. And nevertheless, the report tells us when women and men have the same rights, the deaths of women and men are more or less the same, which calls our attention. And here we have the figure. In the cyclone in Bangladesh in 1991, 19% of the people who died were women, 140,000 of them. And we could give more detail why, but there are many reasons and we cannot go in depth. I just wanted to call your attention on this. Or the tsunami in 2004, as we see here, 65% of the victims were women. It calls our attention and tells us that we have something to do. And one of the things that we have to do, and that is one of the agendas of the UN, is the protection of civilians. These are activities addressed to ensure the security and the physical integrity of the civilians, especially children, women, and other groups in situation of vulnerability. And what does it say? The protection of civilians to the peace operations. It says that our actions, when we plan them, we have to consult with the civilian population. You know, for instance, the units of civil military the relations that is called integral relations. So you have to talk with the civilian population of all types and condition, and women from one group, ethnical group, another ethnical group, poor women that could be under a situation of vulnerability, and talk to them to plan with gender perspective where the opinions of these women are included. And the military component has the role to protect against the sexual violence, focus especially on the persons that are most vulnerable, like women and girls. In the emergency response, for the humanitarian response, it is important to ensure the same access for women, especially women with disabilities, and then for men and girls and boys and girls. Many times, the humanitarian action does not take this into account, and it is very important for us to collaborate in this distribution of assistance with equal access. It is very important, this deployment of military personnel. It's crucial, especially in the task of civilian task, but in any task at all. I don't want to give reasons or to justify, but I want to explain it so that those that are listening can understand. Military women interact many times better than men with women and children, especially with persons that are victims of sexual violence. But the military women in many countries have access to 100% of the population, and men only have 50% access. And this improves our access to information and intelligence that is so important for the peace operations. Women are also very visible for the civilian population, and this empowers the women and local girls, especially if they want to participate in the security sector of the country where they are found. Uniformed women are an example for local men and women. It is also important to create an early alert for exchange of information. if we have relations with the civilian population, we can say, look, friend, if you see a situation where there are people shouting and a man with a machine gun and saying that they're going to kill, let us tell us, because this could mean that people could be killed or raped. And so with the population, we need to exchange information. And for this, we provide them with equipment, maybe just a telephone or a radio, and but something so that they can communicate these situations of vulnerability and early alert. But we have to be very careful that this civilian population doesn't suffer the reprisals of these armed groups. We have to think all the time in the famous no harm. But it is very important to have this exchange of information with the population. It helps us a lot. Now, we also have the handbooks for the military that talk about the behavior of the persons that are working in peace operations. They have to be trained to not tolerate any sexual abuse. Not only not commit it, but if they know about it, they have the obligation to inform, even if they're not witnesses, even if it's just hearsay. And it is important to pre-deploy, and you have to train these people again in pre-deployment in human rights, their behaviors, the standards of conduct, etc., especially to the heads and the staff. And this is commanders and staff, because even sometimes officers, the higher they are, they need this. And they say, no, I know this. And I am aware of this. And it's not like that. The commanders, all the superiors have to participate in these trainings. Why? Because at the end, these commanders are the ultimately responsible persons of the conduct and discipline of their staff. And if they commit any type of abuse on human rights against the civil population, the responsible persons will be responsible. The planning considerations. In the planning, we have to include the cooperation in human rights. It's crucial. And here we're going to share a lot. We have to work a lot with the component on human rights. And in the plan, we have to include the security patrols to protect the most vulnerable and to get information. And in the design of the plan, we have to add it. We have to enter the gender perspective in the development and execution of the operation. And we have to put the advisor in gender, or the persons that are focal points on gender in this plan, both at the operational and tactical levels. I'm showing you here what I call the card, the planning of abuses against human rights. A uniformed personnel have to have this in a plastic cover in their right or left pocket, because this is the Bible of prevention, where they can learn about their obligations, international obligations, and what is the prevention of human rights abuses, and it explains what we have to do and how we have to inform. And this is very important to continue with the famous how that was explained before, and I'm not going to explain here, but you will have it in the presentation. This is very important and very relevant. And also in any planning, we have to use this gender checklist, where we have questions that we can make if we are just cross-cutting in the gender perspective in the planning. These are our examples. We have many handbooks of the United Nations and NATO, where we have all these lists to check if we are implementing the gender perspective or not. It is also very important when we do a gender analysis and we include the gender perspective in our operations. We have to study, especially if we deploy from one country to the other, and understand the historical culture and legal culture, because it's not the same in Belgium or France or Japan or Afghanistan or Colombia. So the gender standards are different in each country, and the role of women are also different. And we have to think that the women has always to go from victim to leaders in all spheres of life. As I said before, they have to interact with the community. For this, we have specific units to interact with women and men, especially the persons in situations of vulnerability. And we have to disaggregate these data not only by sex, but age, persons with disabilities, persons from different ethnic groups, etc., gender, that will help us have much better and efficient planning for our mission and for the operation. And I'm going to end by showing you something that, you know, the rules of the Code of Personal Conduct for Blue Helmets, and it highlights the importance of the treatment of the persons in that country where they are, with courtesy, respect, with not infringing any act of sexual abuse or psychological or physical use against the civilian population, and always respect the human rights of all the persons that we find in here. And now the questions.
Muchas gracias por su presentación, mi coronel. Muy concisa, con muchos puntos muy importantes. Destaco los conceptos que iniciamos hablando.
These are some of the concepts that we started discussing, that all soldiers have this obligation of not only being spectators of any type of sexual violence, the risk levels under which women and girls are submitted to, and lastly, the practical and important documents such as the gender checklist. My Colonel, now we have some questions that have come because of your presentation. You talked about the roles and the military components, but we have one question with regards to coordination, and I will read the question. In a peace operation, we have military and police components, and the UN and other humanitarian agencies. How can all of these actors coordinate with one another with a gender perspective? This is a very interesting question because for many years, military institutions and institutions that were in charge of humanitarian assistance were going about with our backs to one another. We didn't like one another. We didn't respect one another. But in the last decades, I think that the relationship is much better. When somebody needs transportation, security, distribution of food, or humanitarian aid, I think that there's more coordination. There are sets of coordination where the humanitarian and the uniformed agencies talk to one another. I would like to mention that there's some sort of a position in certain countries where the humanitarian issues are harder, and it's called GENCAP. These are senior gender advisors, and these people have the capability to coordinate at a very high level with OCHA and the Peace Corps, everything that has to do with gender activities. These are GENCAP, the senior gender advisors and protectors. Thank you. Another question, how can IAW and OAS protect women in vulnerable situations? Well, the first thing I would say is, if I was from IADB and the OAS, I would try to have a liaison with the United Nations, with NATO, OECD, African Union, European Union, to create some sort of link where we can exchange not only manuals, because manuals are documents, but also to have a discussion, especially with uniformed staff, be it from the police or the army, and to coordinate humanitarian assistance. For example, at the United Nations level, they have a meeting where they exchange good practices. So I would like to have this sort of link among all of these organizations to share those good practices and to see how others are caring about this. And taking into consideration that other countries, and I will not name them, have a very good routes that are very well designed but they don't work. These grievances processes do not work because they don't hold confidentiality. So we need to learn from these institutions and countries where things are being done well and where they have disaggregated information about these complaints or grievance mechanisms. I think this is the most effective and efficient way to do it. Thank you. And the Q&A session is up for Colonel Jesus Gil. And my dear Colonel, on behalf of IADB, I would like to thank you for your presentation, and we invite you to be part of the audience. Thank you very much, and good day to everyone who has joined us today. So before the next presentations, the representatives of the CICR, I would like to show a video of their exceptional humanitarian assistance within the framework of this great movement. Around the world, we help people who suffer war and violence. As a neutral organization, we work on the front lines and to evacuate those who have been hurt and to distribute essential aid. We look after everybody who has been hurt, no matter where they are. By the virtue of the Geneva Accords, we would like to see that all detainees have a respectful assistance and they keep in contact with their relatives. We would like to remind you that even through conflict, war needs to uphold certain standards. And when the chaos of violence separates those families, we help parents, sisters, brothers to meet again. We do not take part. We are the International Committee for the Red Cross. Right now, we have the presentation by Ana Luisa Cinta Narváez. Miss Ana Luisa Cinta Narváez, she's a coordinator before the Army Forces of CICR for Mexico and Central America. And on her professional experience, she has carried out several studies on matters of international humanitarian law and human rights, as we see her bio on our screen. Good morning, Ana Luisa. Are you able to hear me? Yes, thank you very much. Perfect. I am able to hear you very well. Thank you for being with us. Right now, I would like to invite you to present the human rights and international humanitarian law in military operations. Thank you very much. I would like to verify that you're able to see my presentation. Yes, we are able to see it. Well, first of all, on behalf of the International Red Cross Committee, I would like to thank for the invitation by the IADB. I would not take too much time on protocols so that I can make the most of the time allotted. I would like to express that the CICR commitment has that humanitarian mission to protect life and the dignity of the people of and the victims of armed force. And as you know, we call them violent situations other than war. And we are putting our efforts to lower suffer by strengthening rights. And I think that this is a privileged space to be able to raise awareness on international standards. And our work is according to the standards that you see on the screen. And this has allowed us to particularly uphold this neutrality, impartiality that we look for. We have the responsibility, all of us that work at this institution, to preserve, of not taking part, of not giving an opinion, not even on public media, on what we see, even though with great transparency, we tell everything that we see. we safeguard the confidentiality dialogue that we have with the authorities. And I won't expand myself on our mission and mandate. I would just like to reiterate that this is just humanitarian, and by looking after life and the dignity of people, is that CICR has a direct link with the protection of some rights specifically. And I know that we are here, and I know that we have attendance of different countries from all of the countries that you see on the map. We are going to have some slight changes in 2024. This is the map for 2023. We're going to have some changes in Panama. And the countries that are being covered by Panama are going to go to Venezuela, and we're going to open a new office in Haiti for 2024. And what is it that we do? Well, we do humanitarian assistance for topics what we see the humanitarian consequences of armed conflict. And I'm starting to link directly with the topic that has to do with human rights and armed forces, because if you pay attention, and it is written there, CICR, it is also facing the challenges that have to do with the application of international humanitarian law and the human rights. And what you see over there on the screen of what we call humanitarian consequences of violence, these are issues, conditions, and situations that are affecting directly the armed forces in the role of the guarantors of the rights of the citizens, and on that fundamental role that they have for the prevention. The armed forces are always part of the solution on topics related to the displacement of people. And we're looking at the countries of our hemisphere. We see not only displacement of people from one country to another, but also displacements within the country, because some of the people, why is it that they move? It is because of violent threats. It is why they migrate. Also, disappearances. Fortunately, we are far from considering armed forces as it was presumed in the past as direct actors of disappearances. Now the role is different. In many of the cases, they have to protect families, people that are looking for human remains, or in the case of Mexico, they provide the perimeter security for those who are looking for missing people. They are also a key element for the protection and the restoring of family links. You can see it there. And who preceded me on the floor talked about sexual violence, the lack of access to utilities, access to health services, and those that are incarcerated are some of the topics that the CICR addresses in Latin America. And the department that I am honored to represent is the one that holds the direct dialogue with armed forces and security throughout the continent. Our dialogue, we consider it fundamental as a core of our operations, because armed forces deploy themselves maybe with a greater scope throughout the territory of the whole hemisphere. And in some of those countries where we carried out our work, we let them know about our deployment, our activities. And I insist, because of having transparency, to have a humanitarian dialogue and to promote respect and dignity of the people. And an added value that we have been able to offer to the Army and the military is the technical support to promote the integration of international standards related to their functions within their internal framework. And I'm not referring only to the issuance of laws, but also in their doctrines, in their systems, in their education, in their training, and on the research of our responsibilities. With all the represented states here on this audience, we carry out this type of dialogue for the promotion of rights, knowing that the genuine vocation is to defend the sovereignty of a country. We are the guarantors of international law, humanitarian law that is regulating all of those functions of the defense of national sovereignty. But in our continent for several decades now, we are looking at armed forces that have to do with humanitarian aid, peacekeeping, providing support at the countries where the United Nations has established the deployment of blue helmets. And it is something that I'm going to discuss about how the Army are working on security operations. And we are not going to have any position on what the military are doing. ICRC is dedicated for being able to see that we are going to be able to provide all the mechanisms and all the resources for those that are exercising the safeguard of people in a way that societies and states are expecting it to happen, and also international community. We have seen that this participation has to do with the degree of violence or the magnitude of certain events, sometimes are more than the capability of the armed forces, and they have had to exercise the activities of the police, like making arrests and also participating at control posts, exercising curfews. And I think that we see this very clearly in Central American countries, Honduras, El Salvador, where the armed forces are the responsibles of enforcing the states of exception. And also the pandemic, and luckily this is very far now, but the armed forces were the ones in charge of preserving the security of the health facilities. Also during electoral periods, they are taking care of public buildings where the polls are taking place. We also see the scenarios of demonstrations, protest. They do patrol on the streets, not in all of the countries. I would like to clarify on this because I'm talking overall of the continent. There are some countries where the security forces are the only ones who hold this role. And I refer to the case of Nicaragua, among many other countries in the region, where the armed forces do not have a direct oversight of all of the things that I mentioned. But I think that within all of these scenarios, there's a common point of them having the power of using force, and this is going to be directly linked with matters of protection of human rights. For many of you, this schematic is known, where we see the legal framework that is applying to the operations where the military are operating, and those that have to do with foreign protection and the direct application of international humanitarian protocols. And the right-hand side of the slide is what we're going to be looking at. The things that have to do with public protection, human rights, international rights, and the national legal framework. I will leave you with a reference of all of those that would like to have an access to publications and the gathering of experiences that the ICRC has done with regards to these topics, where we have seen the need to integrate these principles of the use of the force on the manuals, on the procedures for operations, on the rules of the use of force, the importance of legality, that this doesn't have to do with having just a specific law on the use of the force. Legality goes beyond it and making it necessary to have the basis on the law for those who are going to be assisting in an operation. What is the type of gear that they are going to be using, the weapons that they will be using. The use of force is an exceptional, extreme measure that only when other resources have been used and when no other resource are useful anymore to be able to guarantee certain stability, it is valid to use the force, and it needs to cease at the moment where the situation has been controlled. This is the principle of proportionality. Fortunately, we are far from thinking about a numeric equivalence or what was the amount of force that they were going to be exercised. Now we know that this has to be measured only by the level of threat and of aggression that they have in front of them. And on the other side, we are going to place the legitimate objective that they would like to preserve, which is precaution. And this is an essential part of our most recent publications that has to do with planning. If there are demonstrations, we need to foresee that there are medics and standing by. Armed forces have indication on how the demonstration is going to be carried out, how many people are coming, and also to foresee exit areas if it's going to be at a venue where people are going to be gathering. Precaution has to do with having an advancement planning and what is the equipment, the gear that they will be using, and how properly they're going to make use of this. And on this very valid exercise, on the principle of the neutrality of the ICRC, we stress on the possibility of having this responsibility of improving the armed forces on what are their lessons learned, when is it that they have to start judicial and administrative processes to be able to address situations or events that are still happening in the continent and that are putting at risk the rights and the protection of the people. This is an area that has to be very well identified as an area of opportunity to be able to provide to the armed forces, because this often happens too. And I think this is human nature of having prolonged that any failing situation is going to put at risk the legitimacy of the armed forces. This is the principles applicable to the use of the force. And I would like to tell you that on the activities carried out by the ICRC with the armed forces and security, we try in all the countries around the world to hold a dialogue with officers and officials, and especially with high-ranked officials who have shared with us that the current challenges that they are facing, and that is linked to human rights, is the increase of violence, as you are able to see on the graphics on the screen. The issues of human rights where the institutions do not have a harmonized accompaniment on the functions that they carry out. It continues to be a limitation on the fulfillment of their mission, the response of a civil society, the type of response provided by command, and the multiplicity of tasks that they are involved in. And I am thinking about the case of Brazil, where some time ago it was on the news that by the intervention and the support of the armed forces, the mines where they were carrying out illegal practices have been controlled. In the case of Mexico, where the National Guard and the Army are protecting the building of strategic infrastructure. They also provide support to oversight and surveillance of certain areas or diplomatic protection. They're always on the lookout on training on international humanitarian law. And what happens? This reality, this operational reality where we are talking about mobile and volatile contexts in which you are acting. We see the case of Peru, Brazil, Ecuador, where they started the year with demonstrations because of government policies or changes. We see in the continent a greater violence in the urban areas, and it has taken governments such as Ecuador to issue decrees to allow the use of devices for personal protection, tear gas, and I'm making this reference when talking about also gangs and also on the devices that are much more sophisticated used by these groups. And this is also posing a challenge on the response that the authorities and the governments must give to these issues. There are also humanitarian issues that the ICRC is assisting. We are talking about this multiplicity of responsibilities and tasks in Honduras. The armed forces are going back to the control of the jail system. And oftentimes, all of these tasks are being carried out without having a proper definition of the roles and the legal framework. I think that in the continent, we have no more than 8 or 10 specific laws on the use of force. Mexico, Honduras for the case of the police, Guatemala for the case of the police, the Dominican Republic. In this year, it circulated among all of the agents the use of force. El Salvador that continues to work under a protocol of joint activities on how the Army of El Salvador together with the National Police have to work together in El Salvador since 2018. In Ecuador, according to the reference about the use of the force, was published in the continent, and also a regulation that has to do with a greater specification about this topic. And what happens? The participation, the multiplicity of a task that they carry out is a reality in the short and the medium term. We still have challenges in the transition. In the case, for example, of Mexico, the National Guard, the consolidation of an institution such as the case of the rest of the institution is still an ongoing procedure. They still have the common variable of using force. And what are the challenges that this type of participation is going to present? This joint participation in some countries, and I go back to the case of Mexico, we see armed forces, the Navy, patrolling jointly with the police at the local level and also at the municipal level. And what are the challenges that this entail? Oftentimes we talk about 2, 3, or more commanders on that same operation, on that same patrol, and without any doubt, the military will have their own decision-making processes, and they need to harmonize those with the security forces. And also they have the responsibility of including humanitarian topics within their work. And on these publications, ICRC has issued one that talks specifically on how to include these humanitarian concerns on the processes of military planning. Intelligence have a solid doctrine, the role, and in many countries we need to develop the operational manual for all of this, and they need to include the humanitarian approach, considering that the main role is going to be issued by the commander with an efficient commanding procedure, is going to be the basis for all military organization that is going to provide all of this process with the integration of this doctrine on processes of command and chief of staff that is going to be effective. And I'm going to go quite quickly. This is the web page that you're going to be able to access, and you're going to be able to see what are the links that have to do with international humanitarian law. All of this regulation related to the use of force on operations of law enforcement. And this is something that was translated no more than 15 days ago into Spanish. It's just recently out of the oven. And this is another reference about decision-making on security military operations, where we have commanders, brigadiers, battalions, and these are here for you. The implication of the military in the use of the force continues to be a challenge. How many cases we have heard about psychological and physical effects on citizens and also on authorities that oftentimes, in a matter of 1 second to another, they need to make a decision that is going to imply, in some of the cases, the lives of others. Nobody like the army, like the military, have those options of saving a life and maybe to end the life of one, to be able to preserve the life of others. But the intervention of armed forces is an increase of risk. There are several commands in the execution of operations, but anyhow, we have different challenges, different topics. The time allotted is always limited. I would like to go on and talk about all the operations and other things, but I wanted to give you an overview of these current realities and also to provide this great task to be able to reflect on these topics, because nobody better than those directly implicated that are suffering these consequences, and they are going to be able to identify and to share good practices and to face these new non-easy realities for the citizens or the authorities. Thank you very much. Perfect. Ana Luisa Narvaez, thank you very much for your presentation that we have learned about human rights and international humanitarian law in military operations. I would like to convey the good news of the opening of the ICRC office in Haiti, and also the key points such as the current challenges of armed forces and the military on their operations, and how ICRC can help the military to prepare better for these missions. We now go into the questions. We have the participation online with special greetings from Paul Martin Silvano for their questions. Thank you very much for your questions. Eduardo Francia from Peru. And the question that we have for Ana Luisa is, what are the difficulties that the ICRC has encountered so that the military can adapt to their doctrine, the human rights and international humanitarian law? And if you have any practices about this, can you share them, please? Thank you very much for the question. I think that beyond what the ICRC has identified, I can share what the military and the security forces have worked with us, and they have shared these references, nothing better than those that are directly linked to it. I will give you two very concrete examples. the integration of the operational legal advisors that exist in some of the countries, such as the United States, Peru, Colombia, among others. But this is something that is still a pending matter in the rest of the hemisphere. How is it that we can make this a reality? To be able to have this creation of this figure of having a legal advisor within operations. This has an economic cost without any doubt. We need to have the support of the command. We need to raise awareness on the need of having one person directly joining the operations. It's not going to be the one that is going to be answering the complaints about human rights, that is witnessing compromising situations, that is going to answer before a judge. They need to have the knowledge of managing and knowing the roles and the good results to be able to guarantee the safety of the acting staff, to be able to guarantee the legitimacy of the operations and to guarantee the fulfillment of the operations according to the legal framework. And that is to acknowledge the skills, to have the proper material. And I insist to consider the humanitarian approach on all of those exercises that have to do with planning, to stop within this whirlpool of realities that the continent is posing to us, and to make a reflection. Where are all of those good practices? Not only to point out the deficiencies, but also to stress on all of those good practices where we have inclusion, integration of rights, when we have laws for the use of the force, when we carry out procedures, the PCO manuals that are going to be providing some provisions for the behavior of the military. Some countries have these procedures, some countries have their legal advisor, and another important tool that we need to highlight as part of education. Education should not be only at the classroom. On concepts, we need to carry out exercises at the military academy with all the security measures to take all those that are studying at the army centers with all the proper security to be able to see what are the risky situations, so that this is going to be able to strengthen and build the capacity and the knowledge that are going to be taught in the classroom, but that are also reflected live. And one last comment, and I hope that this is going to be a preamble to the presentation of my colleague, which work I respect and I admire, and they're going to be talking about cybersecurity, to think about what is the response that we're going to be providing to this type of realities that we have in front of us, autonomous weapons, drones, and we need to generate this reflection that is going to take us throughout time to good practices. Thank you very much, Ana Luisa, for your answer to the very fruitful question, and also as a preamble to the next speaker. Thank you, Ana Luisa. On behalf of the Inter-American Defense Board, I would like to thank you for contributing to this seminar, and we invite you to continue in the audience. Thank you very much again, and have a great day.
Con la colaboración de la doctora Romina Morelo, del Comité Internacional de la Cruz Roja.
Of the Romina Morelo from the Committee of the Red Cross. She has a master in public international law in the Netherlands. She is a regional juridical advisor for the Americas for the CICR, and she coordinates in all the region. Dr. Romina implements key themes like the protection of family ties, disappearances, the prevention of sexual violence, and forensics. Can you hear me, doctor? Yes, I can hear you. Can you hear me? Perfectly well, doctor. We hear you very well. Dr. Romina, before your presentation on behalf of the IDB, I would like to thank you for your continued collaboration with our seminars, the same as last year. We have the new collaboration of the doctor in the issues of humanitarian international law, which has been very illustrative and advantageous. Doctor, I invite you to start your presentation on the application of the principles of human rights and the international humanitarian law that will be in English. Thank you very much.
Perfecto, doctora, acá le vemos muy bien la pantalla, por favor.
Okay.
Ahora que se ponga en tela entera, por favor.
Sí.
Está al revés, doctora, por favor, se cambia el... Ahora no tenemos la pantalla. Tranquilo, tenemos... Con tiempo arreglamos. Perfecto, ahora compartimos la pantalla. Por favor, doctora, ¿puede abrir su micrófono? Acá le vemos muy bien el documento abierto. Perfecto.
The document is open right now.
Disculpen, ¿pueden ver? No.
Solo no hay pantalla de los... Tranquilo, doctora. Todos los temas de informática, todos nosotros pasamos, ¿no? Con la pandemia somos expertos en problemas de
Bueno,
informática.
estoy intentando nuevamente.
Sí.
There are
Ahora.
some technical problems.
Perfecto. Miramos la pantalla muy bien. Así, ahora se
Estoy
puede...
intentando presentación.
Está bien, doctora. Puede pasar así que está bien. Miremos acá muy bien, tranquila, tenemos tiempo. Muchas gracias y sabemos todos que eso pasa con todos nosotros. Muchas gracias, doctora.
Thank you very much, doctor. I think that you cannot see it.
No están viendo en completo, ¿verdad?
You're not seeing it in a full display. No, not full display, but we have a good part of the screen with your presentation. If you put it in the presentation mode. Now it's perfect. Can you pass it because I sent it to you as well so that we can see it better. If not, it's going to be very small. And excuse me for taking your time. We have enough time, don't worry. It usually comes out here. Do you have a display settings? Yes.
On the top of the screen, go to the left. Display settings. Yes, almost there.
Here, show taskbar.
Yeah, the other one, display settings. Display settings, the other one.
Here is mute. I cannot see it.
One more to the right, please.
Participants, chat, Q&A, you share more. I'm sorry.
No problem, doctor.
But where is display settings? I cannot believe that this is happening.
Yeah, no problem, please.
Let
No
me try
problem
it
at all.
again.
No,
Otherwise, I will just
Yeah.
Do it like that. And oh, I can see it here. Yeah. Sub presenters. Okay. So can you see it now or not?
No.
Okay, let me see.
Okay, now move on. Okay, now I have the slides here.
Okay, again, I cannot.
Slideshow, please. Doctora, por favor, si puedes solo disminuir la barra de notas y empezar la presentación, está muy bien.
Okay.
At the note bar, you can start the presentation.
No, I cannot do that either.
No problem, Doctor. Come on.
Is it possible for you, for the organizers to make the presentation in the big?
We are taking the presentation here.
Sorry, because I think it's going to be confusing if we have like a very short, small screen. This is a complex matter, and I'm very sorry that this is happening.
Can you try again, because we detected that we have the presentation so big that we have problems to charge here. Okay.
Trying one more time.
Okay.
Hopefully this will work. I cannot see display settings. That's the thing. Can you see it?
Yes, we see clearly here. But it's okay, Doctor. Please, if you can start, will be perfect.
Yes, I'm sorry.
No, come on. Please, thank you so much.
So if in any moment you see that you can pass the presentation and make it bigger, that would be, I guess, better. So sorry for all of these and for taking the time of this important, I would say, presentation due to the current situations that we're living in the world. First, I would like to, of course, thank the Inter-American Defense Board for this invitation. I have participated in previous years, so this is very, very, a very great honor for me to be here present with you today. The presentation will focus on three main areas. So the main, the first part will be on which are the military uses and human cost of cyber operations, which should address then which are the legal solutions that we can see in IHL to address those humanitarian risks. And in particular, we are going to discuss on the notions of attack and the data as civilian objects. So what are the humanitarian risk posed by these cyber operations? As you can see, of course, during armed conflict, cyber operations have been used in support and alongside many of the kinetic operations. So these cyber operations may offer alternatives, of course, that other means or methods of warfare do not necessarily have. So on the one hand, the cyber operations can or have the potential to enable the parties of an armed conflict to achieve their results without harming civilians or even without harming civilian infrastructure or damaging the civilian infrastructure. But on the other hand, we also have seen in recent cyber operations that mostly have been conducted outside of the context of armed conflict, but that could eventually be conducted in the context of armed conflict, that show that sophisticated actors have developed the capability to disrupt the provision of essential services. So this means that it is possible for the belligerents to infiltrate a system, to collect, to modify, to encrypt, and to destroy data. So it's also, of course, possible to trigger and to alter these different and manipulate the process, which could have a very strong effect in our daily life. As we all know, we live in the cyber world. We count on the cyber domain, as we call it, for almost everything. Actually, for this type of gatherings or seminars, we are doing it through the internet. So the effects that any cyber operation that would not fulfill the requirements of international law, whether it is international human rights law or international humanitarian law, of course, will have a big impact and a great harm to humans. So based on, of course, the discussions that we have had with different experts, as well as with the observations that we see in the field, as was mentioned by my colleague before, we have delegations in all over the Americas, but also in other parts of the world. And we have seen that medical infrastructure has been ultimately very much targeted. This is something that we experienced regretfully during the pandemic. So even though this was not necessarily during an armed conflict context, we see medical facilities being targeted more often. Even humanitarian organizations are targeted more and more often. So we, as a movement of the Red Cross and Red Crescent, we have been targeted with a cyber operation. So this is increasing. Of course, that if we take these type of cyber operations to a context of armed conflict, what we can see here is that people that are already vulnerable, let's say people that is sick, prisoners of war, people that are under siege in a territory of a conflict, are going to be even more affected if they cannot have electricity because there is a cyber operation or a cyber attack against a power plant, or if they cannot go to the doctors, or the doctors cannot really work because their systems are blocked. So the potential human cost of these cyber operations that do not fulfill with the principles of IHL are very, very big. And we are glad to know that this was highlighted by the international community. So I put here in the page 2 of the examples, 2 recent reports, one of the group of governmental experts in the framework of the UN that have expressed that this type of harmful ICT activity is very serious. And also the open-ended working group report. The difference is, of course, an open-ended working group has much more participation, and the other one is a group of experts related to the cyber realm. But even the open-ended working group have said that states decided or concluded that there is devastating security, economical, social, but also humanitarian consequences of this type of cyber operations. So this is a reality. We all know, and of course, I also want to mention 2 of our publications that specifically target which are the potential costs of cyber operation, with examples from the field and from the work that our colleagues normally do in the field and the information that they can receive. I don't want to take more time of this presentation to dive into these potential human cost of cyber operations. However, I really encourage you to have a look to these reports, because it contains the information that can make us realize that this is not the future, that this is happening now, and is having real consequences in our daily life. So now the question is, how does international humanitarian law address those risks? We have the risks. Are states or non-state armed groups acting in a legal vacuum? Or do we have already norms of international law that could be applicable? So first of all, because I'm a lawyer and we love definitions, in order to start speaking about the application of IHL, International Humanitarian Law, to cyber operations, we need to define what we think it is a cyber operation during an armed conflict. And as you can see in the screen, regretfully it's not that big, but I'm trying to, let's see if I can make it like that. Oh, maybe it's better. Okay. An operation against a computer system or network or other connected device through a data stream when used as mean, and this is very important, or method of warfare in the context of armed conflict. So as it was mentioned before, but I would like to highlight, we are, as International Committee of the Red Cross, when we talk about the application of IHL to cyber operations, speaking about when these cyber operations are used as mean or methods of warfare in the context of armed conflict. Because as you know, but this could be a reminder, IHL is this area of international law that applies and that governs and regulates the conduct of belligerents during an armed conflict, with the objective, of course, of protecting civilians or those that are not anymore participating in the hostilities. Some call IHL law of the armed conflicts, some call it jus in bello, and has to be differentiated with the jus ad bellum, which is the branch of international law that specifically regulates whether the use of force is legal or illegal. And this is important because of the attribution of a cyber operation. I will not be able to include it in the presentation, but maybe during the questions and answer we can tackle that. But this difference is important. It doesn't matter if the use of force was legal or illegal to start an armed conflict. When we have an armed conflict, IHL should apply. And I will make this presentation on that basis. So now there are two dimensions regarding the applicability of law to cyber operations. The first one is whether it applies or it does not apply. And the second one is how it applies. So this is a question for you. Normally I have a woo club, but I think that there are so many participants that it's going to take too much time, but you can start thinking. So do you think that IHL applies to cyber operations during armed conflict? So for us, for the ICRC, this is not there is no question that IHL applies to cyber operation, therefore limits what the cyber operation during armed conflict, and regulates the use of any weapons, any means or method of warfare, whether they are old or they are new. Of course, there is a discussion that cyberspace, and actually there is no agreement on whether cyberspace is a new domain or is even a domain. So for us, it doesn't matter if it is a new domain, is even a domain, or is just a part of the domains that we already have, like, I don't know, air or outer space, for example. What importance is that IHL already includes the states that have negotiated and ratified the treaties of international humanitarian law already have agreed that many of these regulations are going to cover the armed conflict, the weapons, the means and methods of warfare for the future. And a different conclusion, we think cannot be arrived to, because we even have Article 36 of the first additional protocol to the Geneva Convention. There is an article that states that all the state parties, the high contracting parties of the Geneva Conventions, have to conduct certain processes to see if the new means of or methods of warfare are legal or are lawful, taking into consideration IHL rules. For example, if a new weapon is not going to be indiscriminate. So we already have this in the additional protocol 1, so since 1977, and this is applicable, was applicable from that moment onwards, and is applicable now. In addition, the conclusion from the International Court of Justice in their advisory opinion on the nuclear weapons, it says that IHL applies to all forms of warfare and all kinds of weapons, including those of the future. So here we think we have a great deal of arguments, at least legal arguments, to say that there is this application. And I want to make very clear, because we have seen these discussions in the international and multilateral realm, saying that if we discuss whether IHL applies or not applies to cyberspace, we are encouraging the warfare in cyberspace. We are encouraging the militarization of cyberspace, and this is not the case. IHL, as have been mentioned, is a restrictive law, so we are putting limits by applying IHL to the cyber operations in order to protect the civilian objects. I want to clarify that, because it was, and there is still some of the countries that are reluctant to discuss whether IHL applies or not to cyberspace because of this. I think it is the same as we have in land. The applicability of IHL is not legitimizing the unuseful use of force. As I mentioned before, there are two branches of international law. We have jus ad bellum, so the legitimacy is going to be decided by the UN Charter. Then when force is used and there is an international conflict, we have the applicability of IHL to protect civilians and to limit the methods and means of warfare. We really welcome that many states have made this step forward, and it was expressed and highlighted in the report, the 2021 report of the GGE, the group of governmental experts, in which they note that international humanitarian law applies in the context of cyber operations only to situations of armed conflict, and that they recognize the need to further study on how it applies. So this brings us to this important question. Okay, most of the states, and for the arguments and the reasons that I mentioned before, say that IHL applies to the cyberspace. But how it applies? Of course, that the cyberspace have a different characteristics, and many of the laws and regulations of IHL relates to the idea of an attack. So we say that direct attacks against civilian objects are prohibited. Indiscriminate attacks are prohibited. So those that have a nature to strike military objectives and civilian objectives or civilians without distinction. We also say that disproportionate attacks are prohibited. So many rules of IHL really relates to attack. So that's why we need to identify what would be an attack under IHL. And the controversy is that how we define it. And it matters because if we can define what it is an attack, we can really apply those prohibitions and those regulations under IHL to restrict the means and methods and also to protect civilians. So what do you think? During an armed conflict, does a cyber operation that disables a banking network in the enemy state for a week would qualify as an attack under IHL? So there has been an agreement already on many of the attacks. So it's widely accepted that a cyber operation expected to cause death, injury, or physical damage would constitute an attack under IHL. And for us, as ICRC, we do not only consider this of direct death or direct injury or direct physical damage, but also the foreseeable indirect damage or effects of the attack. For example, it would be the death of patients in intensive care units caused by a cyber operation on the electricity network that results on the cutoff of the electricity in the hospital. So the direct effects of the attack is that there is no electricity, but the indirect effects that are expected from that specific attack would be the death of all these people in intensive care in a hospital. So there is much more, and is almost unanimously accepted. Of course, there are some states that do not agree necessarily with that yet, that these type of attacks would constitute an attack under IHL. However, sorry, as I mentioned in the question, what happens with those that are disabling the systems? For this, we have to go to the rules. We already have a definition of attack. So on Article 49 of Additional Protocol 1, attack is defined as an act of violence against an adversary, whether in offense or in defense. We have disagreement on those that cause injury, those attacks or cyber operations that cause death. But for the loss of functionality, we have different views. And this keeps changing. So there is a narrow view. There are those states that think that only operations that cause death, injury, or physical damage can be considered an attack, and those that have a broader view. So also operations that disable a computer or a computer system can be considered an attack. And we encourage states to continue discussing this type of specificities of the applicability of IHL, because of course, if this cyber operation is an attack, it will be, IHL will be applicable and the protection of civilians is necessary. So for us, an overly restrictive understanding of the notion of attack, such as the narrow view, would be a little bit difficult to reconcile with the object and purpose that IHL, that International Humanitarian Law rules and principles have. Because if we only refer to these operations that cause death, injuries, or physical damage, those cyber operations that are directed to making a civilian network, it could be banking, it could be electricity, it could be communication, dysfunctional, might not be covered. And as I mentioned at the beginning of my presentation, almost all our life works on the internet. I will not, I have very little time, sorry for that. I will just leave the other issue and the other controversy is whether data, so all the information that we have in the internet can be considered as an object under IHL, because as we know, IHL prohibits the direct attacks against civilian objects. And by definition, objects are things. So is data an object under IHL? Because otherwise it would not be protected. Here we have different opinions in the international realm. Some consider that data is not an object because it's not visible and tangible. Some consider that it is an object and it must, cyber operations against data must comply with IHL. That is our opinion as well. And some other consider that some data are objects and some other data are not, depending on the content and whether they are operational data or not. We believe that the replacement from like paper files to data should not take away the protection that these civilian objects had. For example, the medical history of a person is not anymore in a folder. It is data on the internet. So the attack or the destruction of this type of data would be, for us, a civilian object covered by IHL. I will skip the conclusions because I already have taken a lot of time, and maybe we can continue discussing during the question and answer. Thank you very much for your attention. And again, apologies for the issue with the computer. Thank you.
Dr. Romina, thank you so much for your presentation. And please don't have to apologize. And I think, as we mentioned, we are all very familiarized with these issues in the computer, so no problems at all. So I believe that is relevant to highlight in our presentation. Very interesting and instigating point. So the new reality of war and how the cyber attacks can pose a risk to the human lives, and also how can the international humanitarian law can address these issues. So very important and very interesting presentation. Well, now we'll move to the questions. We have some questions here and we are here in the presentation. So please,
Gracias. No sé si preguntar en español si hay traducción o entrar directo en inglés.
También puedo contestar en español.
I don't know if I should ask the question in English or Spanish. In Spanish, it's okay. Just thinking on the last thing that you said, because we have a real case that all these children and babies in the units of intensive care in Israel, and all those babies died. Now, it wasn't an attack, obviously, but if anyway, all the infrastructure and all the real infrastructure was destroyed first. And so my question is directed to the way how you can legislate, or the way that you could eventually sentence or condemn the fact that those machines were turned off. It could have been a cyber attack, but maybe they didn't know the technology, but it's happening. So how can we prevent this from happening? Thank you so much for your question. Of course, as was mentioned in the video, the International Committee of the Red Cross is a neutral organization. Therefore, I'm not going to refer to specific cases or conflict situations that are specific that are happening in the world. But I can answer the question in a broader way. Here we're not talking about cyber operations or cyber attacks, but the applicability of the international humanitarian law in an armed conflict. And as you know, there are some key principles that have to be applied and respected. The principle of distinction, launch the attacks just to the combatants in the case of an international war, or the persons that participate directly in the hostilities or have a contact function, because we're talking about a non-international conflict or the military objectives. Unless, and that is the first thing, but let's suppose that we're sending an attack to a military objective and there could be some incidental damages. And then you apply the second principle, that is the proportionality principle. What is the advantage that the military advantage has to be greater than the incidental damages. And that's where we have to consider all the damages, not only direct, that are going to be caused maybe by firing a weapon that has an expansive effect. And then we know what the radio is of the expansive effect of this weapon, and we can calculate the persons or the amount of people that are going to die. Or there are also weapons that are being used a lot because the ultraspace is a military operations environment. So there are many weapons that are being used now to cut communications. Before it was radio, but now communications of the satellite, and to avoid the use of Google Maps and any other geolocalization issue, and to invalidate some civilian systems that are around this. So when you're doing the analysis of the proportionality in the attack, you have to keep in mind exactly this type of effects, not only direct effects, but also the effects that can be caused in the civilian typical infrastructure. So like a current of electricity, access to water, and even the management, for instance, of a dam that could generate energy. So all this has to be taken into account. And finally, and I don't want this outside, we also have to take all the precautions necessary in the attack and defense. And this is very clear. These precautions have to be done in all the measures possible to avoid greater incidental incidents than the military force. And this has to be taken to the cyber. And in the case that you mentioned, that there was not an attack, but they just destabilized the existing services. We're talking about the application of the IHL and on land and probably air. But also we have in the cyberspace, you have to apply the same principles, and that's why it is fundamental to determine what is an attack, a cyber attack, and what is a civilian objective in the cyberspace. So if there would have been a cyber attack to a hospital by which all the means of intensive care of the patients cannot work, the damage and the deaths of these patients have to be kept in mind at the moment of analyzing. First, let's suppose that in the hospital you had kept weapons. Maybe it could be considered as a military objective. To analyze the proportionality, you have to consider this type of effect that you will have, but not to forget first the description. It's not the hospital, and the hospital is especially protected by some humanitarian international law. We have to take into account that first we have to go through all these elements. Did I answer your question?
Muchas gracias, doctora, por su respuesta muy completa. Tenemos muchas otras preguntas, pero lamentablemente llegamos al fin del tiempo.
Thank you, doctor, for your questions, for your answer to our questions. And we have more questions, but unfortunately we don't have more time. And thank you on behalf of the Inter-American Defense Board. Thank you very much for participating on this seminar as a speaker. You can join us in the audience and have a great day. As we announced at the beginning of this seminar, we are going to have a brief break. It is 11:07 in Washington. We are going to take a 10-minute break, and we will be coming back at 11:17 in Washington.
Señoras y señores, reciban por favor
Ladies
una
and
vez
gentlemen, again, we greet you deeply and welcome back again. Now we go on to the next and last block on human rights and international humanitarian law at the Inter-American Defense Board. Before we go into the next presentation, we would like to thank Laura Brendoscolo for the support of the distribution of the seminar. Ms. Laura, our appreciation from the Inter-American Defense Board. Also, I would like to thank the participation of the audience with questions. We appreciate it that you have consideration for our questions. Now we go with Karim Marcelli. Karim Mancel is a Peruvian lawyer and master with public international law from the Leiden University. She works as a specialist on human rights at the Inter-American Human Rights Commission with the OAS. Good morning, Dr. Karin Mansell. Are you able to hear me? Yes. Good morning. Can you hear me? Perfect, doctor. We hear you well. Right now, we invite you to give the presentation on human rights and international humanitarian law in the Americas. The floor is yours. Are you able to see my screen? Yes, doctor. Thank you very much. Well, first of all, I would like to thank the board for the invitation on behalf of the commission. It is always a pleasure for me to participate in this sort of events. And I would like to thank the previous speakers for their presentation, and it's a good introduction for my presentation. I'm going to talk about human rights, international rights, and HIV in the Americas. The objective of my presentation and the objective of IACHR in the Americas, and my presentation has to do with international humanitarian law through its different mechanisms, and especially in the system of cases. The Commission and the Court have always used international humanitarian law for situations where violation of human rights or situations of conflicts have happened. I would like to separate the state responsibility and the individual responsibility. The Inter-American system focuses on the responsibility of the state, not on the individual responsibility of state agents. But to analyze state responsibility analyzes whether the state agents is according to the Inter-American Convention. Since the beginning, the Inter-American system has identified common core of unviable rights on international humanitarian law and human rights, and that is to protect the physical integrity and the identity of the human being. It considers that in situations of internal armed conflict, these two branches of the law are merged and they correspond to one another reciprocally. This common link is established at the Inter-American Human Rights Commission, and it is on Article 27, and this has to do with unviable or undeniable rights when situations of human rights arise, and that is the protection of life, the prevention of slavery, retroactivity, awareness, religion, the right to family, the rights of the child, nationality, political rights, and the judicial guarantees, and the arbitrary prohibition of freedom. This is the common core that is repeated in Article 3 as one of the Geneva conditions. This is the common core between the two bodies of rights, which is what the court and the commission are going to review in their cases to be able to see if there's a violation of rights by the state. The system has applied international humanitarian law for the conflicts of Guatemala, El Salvador, Colombia, Peru. These are the examples that are presented at the Inter-American system, and they have applied Article 3 common to the Geneva Convention, Protocol 2 for the non-international matters, and customary law. The International Convention for Human Rights is not providing for conflict, so it doesn't have provisions on the use of force and the methods of war, but it is being used so that in situations of armed conflict, international humanitarian law is going to be a special law for the interpretation of the convention and other human rights instruments. The IACHR, since 1985, since the Blake case in Guatemala, referred to this core that I have been discussed. These are undeniable rights that are protected on human rights conventions and also at the international humanitarian law. And they consider that these instruments are of concurring application and they complement one another. It is being used mainly as a source of interpretation, which is different from applying international humanitarian law for applying international responsibility. The IACHR cannot apply international responsibility because of the application of these conventions. We are going to be discussing key cases that exist in the system where the committee and the commission and the court have had to use international humanitarian law to try to explain whether there was a violation of human rights according to the commission. In the case of the first was Colombia in 2000. The court said that they don't have the authority to apply international humanitarian law directly by deriving a state responsibility, but they used it as an element for interpretation. Also, in the case of Bamaca Velázquez in Guatemala in the same year, which was the disappearance of a guerrilla person, and they analyzed that it was that it could take into consideration the violations of the IHL, and it took into consideration the Geneva Convention, particularly Article number 3. Likewise, in other cases of Colombia, such as the communities of Cacarica, which had to do with the displacement of communities because of paramilitary incursions with the cooperation of some state agents, the court took into consideration the distinction, proportionality, and precaution principles on the use of force within the framework of the armed conflict as a non-international character. And it was an opportunity to refer to these standards with regards to the displacement because of armed conflict. And they related to certain norms or standards of the international humanitarian law in order to see if there was a violation. And so they refer to Protocol 2, Article 17, that forbids to order the displacement of civil population because of conflict. In the case of Chavín de Huántar in Peru, the court decided in 2015 that it was a legitimate use of force by the state in this concrete case. This was a hostage taken at the residence of the Japanese ambassador in Peru, and the military operation by which the hostages were freed. And they did this because it was useful to use international humanitarian law for the interpretation of the convention, and they analyzed the violation of Article 4, which is the right to life, taking into consideration distinction, proportionality, and precaution principles. The controversy in this case, it is important to mention, it was not to determine whether the members and the state were guilty or innocent, or that the members of the group that took the hostages were guilty or innocent. This is not what the cases are about at the system. It had to do whether the state agents were complying with the standards provided in the convention. And in this case, they were trying to see whether 3 of the members of this group had left the weapons at the time that they died, and whether it was part of the hostility or not. And the court determined that one of them died while it was in the custody of the state, and there was a violation to Article 4, the right to life, and so that the state was responsible of an extrajudicial death, and the other people died during hostile retaliation. And these are complex and important cases that the court analyzes on the violation of human rights. In the case of events of conflict, then in 2014 in Colombia, the court applied in the international humanitarian customary law. The Commission applied this on their complaint, specifically Rule 98, where forced disappearances are forbidden, and the arbitrary incarceration, and they use Article 3 of the Geneva Convention, stressing on a special and general rights to protection of civil population. This case, we referred specifically to the prohibition by the ICRC on the arbitrary incarceration, and this is not susceptible to the suspension during armed conflict either. There have been cases where the court has used international humanitarian law for the restoration, and sometimes in situation of conflict, international humanitarian law has not been applied because human rights offer more guarantees on those specific instances for the protection of the lives of the victims, like the case of Colombia in 2016. And I also wanted to mention the Santo Domingo massacre case, where there was a use of a machine gun from a helicopter, and the court took this case to analyze the precautionary principles and detention principles with regards to the respect of life with the victims, and also the special protection of boys and girls. And in this case, 17 people died and 27 were injured, including children. So what the court did is to look at the precautionary principles and distribution principles and distinction principles, and whether the state agents acted according to the standards of the use of the force. the Commission and the Court will provide recommendations or reparations in those cases. And usually, if these are cases that have to do with armed conflict, they have training for members of the armed corps. For example, education on human rights and international humanitarian law that are going to be on a permanent basis, or the adequation of the standards to inter-American standards. These are two types of reparations that are usual for this type of cases. And the Commission specifically has made statements on the murder of civilians, hostage taking of armed groups such as FARC or the ELN, and they make statements on their annual reports, and they have also made statements on the use of mines as a weapon. And they also have the report on terrorism, and it has lots of components with international humanitarian law, and also precautionary measures for the reparations during armed conflict, or the processing and detention with a preventive approach for prisoners of war, and also to support the peace process of Colombia before the OAS. International humanitarian law goes throughout all of the mechanisms of the two institutions in the system, in the resolution of cases and also monitoring. Also, in transitional justice and after conflict, there's this merger of the international humanitarian law and human rights, because both require sanctions from those that have made serious violations to international humanitarian law or human rights. And on this, the system has been quite strong by saying that amnesty law do not allow for the investigation on violations of human rights. And so they have requested the adaptation of internal law to international standards. This has been an overview of the interaction that international humanitarian law and human rights law and international law have at the region within the actions of the two bodies of the Inter-American system. Thank you very much. Dr. Karin Mansell, thank you very much for your presentation, where we have learned about human rights and international humanitarian law in the Americas. I think that it is relevant to highlight the distinction between individual and state rights and the duties and obligations of the institutions, and the presentation of key cases where we are able to see how the Inter-American Court for Human Rights have applied international humanitarian law, human rights, and international law. Now we go on to the questions presented and addressed to Dr. Karin Mansell. And the first question is, what is the big challenge so that the states can enforce the human rights and international humanitarian law? Thank you very much for the as you understand, this is
Los estados se han comprometido a cumplir con la Convención Americana y cada cual tiene diferentes niveles de desafío.
The states have committed themselves to comply with this, and there are some judicial freedom, discrimination, corruption, more related to the topic that we are talking about, and the other one is the protest for the indiscriminate use of force. And there are some other states that have challenges with the freedom of speech or expression. The Commission monitors the situation of human rights in the region by country and by topic, more related to the groups under situation of vulnerability and through their rapporteurs of women and children and some other rapporteurs. And right now, in their study, we have been able to see that the regional topics are the rights of migrants, which is a great challenge. And in different stages, depending on the governments, we take into account different challenges. Last year, the Commission identified some issues like the avoiding democratic institutionality and the judicial freedom and the criminalization of justice operators and human rights defenders and the obstacle to the task of journalists. There are states with high levels of impunity and corruption and the increase of resorting to the states of exception as a measure of citizen security. This has been also identified. Thank you very much, Doctor, for this clarification. A last question, due to time constraints, is how align the principle of non-prescription of lesser humanity crimes with the prohibition of the application of the retroactive law for cases in the past. This is a very important question for this forum. The prohibition of retroactivity does not apply in the severe violations of human rights. This is something that I want to clarify, because the issue that is broken here is the type of violations. What is it? Human rights violations or lesser humanity crimes? This is related. This question is related to the amnesty laws, because lesser humanity crimes are not susceptible of amnesty, and the states cannot invoke them to avoid the trial of these crimes. To this respect, the court has determined that they are not admissible in amnesty when they have already prescribed, or to try to make it impossible to investigate these cases of severe violations of human rights. The court sanctioned it in the case of Humanitarian against Chile, and said that the state could not argument any prescription and retroactivity of the penal law. This is one that has been already agreed in the international arena, and no type of similar exclusion could excuse the responsibility of these persons to sanction this type of crime. I also wanted to add that if we refer ourselves to the crimes of the past, even when these were committed in the time in which they were committed, the prohibition of committing lesser humanity crimes was a jus cogens. They were principles of international law. It was a norm, so it would not apply either, the retroactivity. And I think that the violation of states to recognize that the law, the prescription of crimes in the cases of lesa humanidad, because we have some members of the OAS that are still pending on this. And just to stress that there is no pardon for lesser humanity crimes, because these are the most serious of all crimes. Thank you, Doctor. Thank you for this clarification. Since we don't have more time for questions, we say farewell, give a farewell to the doctor. On behalf of the IDP, I want to thank you once more for your cooperation with our seminar, and we invite you to continue with us. Thank you very much, and we hope you have a very nice day. Thank you. At this moment, we are going to be accompanied by Dr. Naja Nasapisi Palma of the Attorney General's Office of Brazil. Dr. Angela is the General Mediator of the Military Public Ministry of Brazil. She graduated in Geneva in international humanitarian law, and her participation from Brazil, we are going to communicate now in Portuguese. Can you hear me? Can you hear me? Can you see me well and hear me well? Perfect, doctor. We can hear you and see you perfectly. Dr. Nasla, initially we would like to record in face of our audience the thanks of the IADB for your continued cooperation with the IADB. We are going to have one more cooperation from the doctor in the human international law that is going to be very enriching. At this moment, doctor, we invite you to start your presentation on the military operations in the struggle against crime, a case study at the light of human rights and the international humanitarian law. The audience is yours. Thank you very much. Initially, I would like to thank the Colonel Talavera for his kind words, and also thank Brigadier Luis de Oliveira, General Director of the Secretariat of the Board, for the honor of this invitation. And I want to greet the leadership of the IADB in this effort of debates that are so important. And I also greet the panel members with their presentations that are so important that we have seen, and that we have even gone ahead of what we're going to debate here. We're going to talk about a case study on in Rio de Janeiro, the military operations in the combat of crime. We're going to try to reflect on these questions that I share with you here. And Dr. Ana Luisa has already developed a lot of this with the topic of international law and combat to crime. And we're going to stop a little bit more on this reflection. Is Rio at war? Does it have the standard apparatus to combat criminality in Rio de Janeiro? We just want to recapitulate what has been said so far. We have an international law of human rights that is applied in peace times, or another one for armed conflicts. The combat of criminality is essentially a function of police, of the police, although in Brazil right now, constitutionally, it can be exercised with the support of the military forces as well. The police, that is this institution dedicated to public security, has as a slogan, serve and protect, and the armed forces defend the country. So here we're going to go over what Dr. Ana has placed already. If we had a hypothetical case of violence, then we, in times of peace, the full application of human rights should be a prerogative. And in times of war, the international humanitarian law and the human rights and interrogable human rights. The greatest vulnerability of rights is when we are before an internal disturbance, especially in the states of exception, because it's not a conflict, armed conflict, and so the international humanitarian law does not apply, because and the one for non-international conflicts. But the fact that some human rights have been stopped, and not life, of course, or some other ones that are key, but the right of movement or the right to assemble do not exist. So we're going to talk about the paradigm of the use of force as an item to compare these, and then continue with the analysis of the combat of crime in Rio. this use of the force is in an operation. If it's a bellic one, a war one, it has, and if it is a police operation, has another type of status, although the military can exercise both functions. And what I want to highlight as important is the use of force in times of war and times of conflict, which is normal. It is not necessary to use lethal force either. The firearm is not a need for the opponent to exercise threats so that the use of force can occur. This differs essentially from the police sphere under the humanitarian law and the internal laws of the country, where the last stage we have to exhaust all the other possibilities before, because the use of force is differentiated. This is an extreme measure when the opponent, and in this case, the action of the force against civilians that commit a crime and that face public security and that represent a threat. It is very important to have this comparison now. To whom is this force addressed to? And we have to see this item on top of the two branches of international law. So first, we're going to present the city of Rio de Janeiro that has a peculiar geography and whose area is on the screen. It's in the middle of mountains and where the combat becomes more difficult because the population is 6,775,561 inhabitants, and almost 1 million of people live in the slums. In the chabolas are like a group of housings that were built in an adequate form and that don't have any public service or basic service necessary. In Rio de Janeiro, we have more than 1,000 recorded of these slums with 5,000 people per square kilometer. Here we have communities in chabolas and favelas to make a comparison of how this situation is so peculiar, because one of the greatest of these slums is Rocinha. The demographic density is 5,000 for 40,000 persons per square kilometer. We have some more examples here with the population of some communities. Why should we consider that there is a war in Rio de Janeiro? Because it is the response of the state is very challenging and it has been insufficient, and this is why we have demanded Rio de Janeiro and the actions of the armed forces to support the security forces, because we also analyze this in this way because the number of deaths in public securities is almost like in a war. There are some they have employed some militaries because the criminals use weapons of war in Rio de Janeiro because they are so well organized and they have the control of the territory, and this is what causes the reflection. And what we will see now is that there are very legal forms, the conditional 2 and 4 of the Geneva Convention as well of 1977 and the Statute of Rome, and give little explanation of the realm of where this is happening. So we expect the response or the analysis of the Red Cross and the analysis of the situation, analyzing the level of intensity of the conflict and the organization of the criminal groups. And there are 3 requirements to read the level of intensity of the clashes. So there is like a parameter, like the number of deaths, the duration of the conflicts, the extension of destruction, the type of weapons and the combat methods, and the type of force that participate in the conflict, and the deployed persons, the number of civilians that are forced to leave their houses, the action of international organizations, and the intents of international representatives to mediate and get an agreement. It is necessary to have the combination, the strong combination of these requirements that the jurisprudence and the doctrine have given us to consider a fact, an armed conflict. So we have to see these pre-requirements in Rio de Janeiro. The number of deaths in these facts are expressed by the institution of the public security in Rio de Janeiro in 2018 to 2021. These are the numbers of people dead and homicides in the city. Almost 1,000 homicides a year. And in the metropolitan region that covers 22 states, in the pandemic year, that number reduced a little bit, as you can see here. Even talking about the number of deaths, there is an index that is measured, deaths caused by security forces. It doesn't mean that they are all considered criminals, but the number of deaths occurred due to their intervention. And this is the number that we have for Rio de Janeiro in the metropolitan area, and correspond more or less to almost 50% of all the other figures that we have seen on homicides and crime. And deaths caused by militaries of the armed forces. In the guarantee of law and order, we have a measure that is not so big. From 2010 to now, we have 32 deaths occurred, not only represented as crimes. Here, I continue with the number of deaths. The police that have died in Rio de Janeiro are a lot. Here we have a record of the military that died since 2010, and we only have 41. So they're enough to say that Rio is at war, and that we need to know what is the cause of the deaths. It is the state that has the least number of resolution of homicides in Brazil. Only 20% of the cases were resolved up to now. In fact, we don't know the cause of these deaths, if they occurred due to personal reasons, or if, in fact, and we estimate that it is so as a consequence of clashes of the criminal groups, organized criminal groups among themselves, or with the security forces. And however, the situation that is so serious in Rio concerns us, and we don't have, this city is not among the 50 most violent cities of the world. Brazil is not among the 10 more violent countries. And to continue with the items of the intensity, the duration of the clashes, this item gives us one characterization, that they are very frequent in the slums in Rio. In 2021, we have 2,500 shots, or exchange of shots in real time. And we have the applications to know where the people heard these shots, so that the people can avoid to go near this region or this place. And the abstention of destruction, which is another item. We have a great amount of munitions and marks on the walls and shells all over. And also with the security forces, we have buses, trucks, and gas stations that have been burnt down. And we have 35 to 40 buses that were burnt as a protest by a criminal group, militia, due to the death of their head. This stopped the city because the public transportation was not able to run. And however, to define the extension, because we know that it is large, but if we compare it to other areas and other regions with armed conflict that are not international, it is not comparable. But but it's not a requirement to strengthen, to be well. with regards to the weapons, we have seized some weapons of restrictive use with more than 2,000 firearms that were seized. Out of these 338, we had rifles, 974 explosives that were seized as well. Out of these 521, we had grenades, 525 grenades. So this is a strong indicator of a war. And we can find that basis here. So why do we have this number of weapons in circulation? Because we have the fiscalization of the weapons, investigation of thefts that is not efficient. And with relation to the weapons that are seized by the police, we have the civilian and the military one with militarized units that are strongly their forces, security forces that are strongly armed. So the clash happens in these cases. Another thing that we can analyze is the type of force that participates in the confrontation and the deployed number of assets. We have employed in Rio military for the guarantee of the law and order. If we make a retrospective look, these are the most important, the most recent actions with models that are different, and the complex of the Amaré and Alemão are two slums that are more distant, they're farther away, and they are occupied by the military that supported the security forces and that occupied these areas and gave the necessary strength for the for police to be able to exercise their job. Of course, there was a lot of policemen in 2017 and 2018. They employed the military in the combat to crime. And this started in 2017. And then the federal intervention of Rio. And we had another design where the military stayed in specific areas, a large number, like 3,000 to 4,000 men deployed in places that were not in rebellion, given safety and security so that the security forces and the police could comply with their jobs. And then they would go back to their headquarters. The most recent one that started this month in 2023 has a different format. The military are at the ports and airports and also at the borders, and the armies are at the border to combat a crime that can impact the city of Rio de Janeiro, the Air Force at the airport and the Marines at the ports. And what are the actions of the military troops? They patrol, they review, and they apprehend those that are found in flagrant crime. All this is in our legislation, and these are called subsidiary attributions. With regards to the intensity, the amount of civilians forced to leave their houses, or that needed to abandon their houses, we don't have so much data on this to see this migration flow. And they're not comparable to areas that have been already recognized as non-international armed conflicts. So eventually, we have some exchange of bullets, but they are not comparable to the areas of conflict. We want to have the international organizations pay attention to the mediation. We need a mediation or an agreement to cease fire. We don't have any news from the organized crime here in Brazil. When we go to the second requirement, which is the control of the territory, access to war weapons, recruitment, training, and the continuous delivery. And if we have a capacity of talking with just one voice and to conclude with agreements. And the most important thing is the capacity to implement basic rules to the international humanitarian law and requirements for the organization. In Rio de Janeiro, we have drug trafficking people, we have a militia, two types of organized crime that have a discipline and a control mechanism. The most known groups are with the green, the Vermelho Command and the Tercero Comando Puro for drug trafficking, and that explore the basic services like the mafia in the old times. But now we talk about the narco militia. These are militias that approximate that business where that are so profitable. And the militia is growing a lot in these times, in the last 15 years especially. If we have a discipline, yes, they have a command with the rules and code of conduct, and also the sentences that are very cruel. There is a general control of the territorial headquarters. Yes, the Vermelho commands or is in charge of the southern part, and from Rocinha, the complex of Chapadao and Alemão. These are the slums that they control. And the militias to the north and west, and the militias in the east or western part of the city. When we analyze these requirements, like weapons of war, we have seen this when we analyze intensity, and the traffickers and militias in Rio have international suppliers, and the flexibilization of the situation in Brazil regulated the supply of weapons and ammunition for organized crime. The recruitment, we have news of some former policemen that are training criminals, even former militaries, so that they can carry out their actions. And there are continuous military operations. Yes, we have the existence of criminal armed operations, but it doesn't seem that they're going to go through an uninterrupted continuity. We have some armed criminals that we call the bondes, but this is not, they don't continue all the time. And finally, we have the requirement for a strategic military strategy. We have only one voice among the armed groups, and the capacity to implement basic rules of human law. No, here I don't see that they're full here. No, this is not uniform. The activity is individual. Each one does what they want, and the state has never thought about negotiating with these armed groups or organized crime. And the principle of humanity does not inspire the violent actions of these organized criminals. They have a social and territorial control based on crime. They don't have the capacity to implement the principle of humanity and the basic rules of international law. And to finish, we need to note that the characterization of an armed conflict that is not international is very difficult, legally speaking, especially in the situation of Rio, and very sensitive. The normative apparatus that we have to apply is international law of human rights and the internal law, even though it's not easy. Our legislation does not fully cover this due to the specificity of the situation in Rio. The armed forces in the combat of crime should be, as our constitution says, exceptional and temporary. And the armed forces need, when they are going to be employed in the combat, they have to be intensively trained in human rights. And it is recommendable always to have the rules of participation and the rules of engagement, especially for those that are the most vulnerable. the situation of Rio does not characterize it to this moment an armed conflict, non-international armed conflict, but it is considered as another situation of violence, and the premise is that the law is always in evolution and the facts as well. So it is a serious disease, so serious like a war. The violence is exacerbated in Rio de Janeiro, and the medicine is not the military medicine that is going to cure that disease. And if we characterize an armed, non-international armed conflict in Rio, where all the requirements are present and not that some are present, some not, as is the case I have shown, I think that we have respected the law, understanding what it means for Rio de Janeiro, these forces, these armed forces, that is going to expose the civil population much more, because we saw that the number of citizens in these areas are a lot, and it does not really help. Well, to end, I leave as readings the International Magazine of the Red Cross. I have an article of the case of Rio de Janeiro with the data I gave you today that are accessible in this website. There are 32 articles that are recent from 2023, and I thank you for the opportunity and your attention. And I greet all those that have been interested, and it is an honor and my pride to talk in front of an audience of the IADB, and I see many people here that have been connected, and it is an honor to have participated. Thank you very much. Doctor, thank you very much for your presentation on the military operations against crime. I want to be very relevant to on 2 points of reflection that were highlighted here in the use of force and the budgets for the
it is completely embedded
within the topic of international
humanitarian
rights.
law.
We have 2 questions.
We have questions from Carlos, Victor Gonzalez, and going into our questions section, I would like to ask you the following. One of the adopted measures to adequate the assistance to international humanitarian law with tactical operations and the participation that will orient the procedures of the troops and the evaluation of the cases that you have studied. The rules were effective in the case of positive or negative. Could you provide us with good practices or indicators? Thank you. Thank you. Very interesting question. I was in Rio de Janeiro almost 20 years ago. And yes, I have been able to provide accompaniment to all of these actions. And it was important to see the existence of rules and their evolutions. I remember that in the Aleman complex, they had a methodology that we participated with the public ministry as attorney generals, with the military, armed forces. We put together preventive action, which was important. We worked on debates, and throughout all of this time, the armed forces were evolving the terminology of the rules of engagement. For somebody who was disturbing the public coexistence, and then hostility went a little bit down. The rules of engagement provided by the military need to reflect international standards, the paradigm of the use of force, of international law and human rights and internal rights. This is something that is a security for the military, because otherwise they're going to be thinking that they are acting right. And if they don't fulfill the the laws and they don't know about the rules, they might be sitting in the bench in trial. So we need to have an evolution of the armed forces, of the military. During a federal intervention, the military staff, the General Defender's Office and the General Attorney's Office, we went together and we wanted to eliminate something that was confusing the armed forces, because if you read it, it looked as though you were going to be able to use lethal force in the defense of property. And in Brazil, it is only going to be used in defense of life, their own life or third parties. And it is not possible, therefore, without having criminal responsibility, without the use of lethal force, that is going to be only for a property, for the defense of property. We have made those changes. Thank you, Doctor, for the clarification on this very excellent presentation. Our time is up. And so thank you very much, Doctor. On behalf of the Inter-American Defense Board, I would like to thank you once again for your valuable cooperation with this seminar. And have a great day. Thank you very much. Stay with us. Ladies and gentlemen, right now we are wrapping up the presentations of our seminar. We would like to thank our speakers for your participation. Before the closing of the event, and because of the participation of over 1,200 participants, and close to 2,000 participants, we would like to present some of the answers of our audience to the questions that we made on our platforms and comments from the platforms too. Can you please verify on the screen the constant reference on international humanitarian law building, capacity building? We have so many participants from different countries, from the military, from civil society, in English and Portuguese, through social networks, social media. Many participations and different audiences that participated today. Now we go into the closing remarks of the Human Rights and International Humanitarian Law in Military Operations seminar. And these are going to be provided by Brigadier Major, who is the Secretary Director of the Inter-American Defense Board. Ladies and gentlemen, good afternoon. With satisfaction and realization, I address you, those who are here and those on internet virtually, to thank the participation on the seminar of Human Rights and International Humanitarian Law in Military Operations. This event, promoted by the Secretary of the Inter-American Defense Board, had the objective to contribute on the strengthening of respect to human rights and the international humanitarian law with the military and security forces throughout the hemisphere, promoting dialogue and exchanges on common challenges to be able to perfect the mechanisms for cooperation among the countries. Now I take this time to convey you some information. We were about 14,000 participants in 43 different countries. So to all of you who are joining us online. The participation on this seminar, it is showing the concern and the commitment to human rights. Each of the participants has cooperated on the strengthening of human rights. Thank you very much to all of you. I continue to celebrate the 75 years on the Universal Declaration of the Human Rights adopted by the UN General Assembly. We need to highlight that this very important landmark presented a change for the world on the installment, but it is important to acknowledge that the journey is far from over. This seminar is witness of our continuous commitment on this journey. During the event, we have heard experts from different countries, and they have been intellectually enriching and fruitful, providing perspectives and experiences that are of great value. Since its creation, since its inception, the Inter-American Defense Board has dedicated to the strengthening of human rights in our hemisphere, promoting productive dialogue, international cooperation in order to develop respect and understanding of these key and core principles. With this seminar, the Inter-American Defense Board is reaffirming its commitment for the promotion of common interest and sharing best practices among the member countries. Again, I would like to express my sincere appreciation for your active participation on this seminar, especially to the distinguished speakers who very generously have shared their knowledge and experiences with us. Ladies and gentlemen, thank you very much. We would like to thank everyone, and with the best wishes for a happy Christmas and a happy New Year, we invite you so that you continue to follow the activities of the Inter-American Defense Board that will take place in 2024 and are now being shared on the screen. We would like for you to take note so that you can join us on the next events. Follow us on social media, the Inter-American Defense Board, promoting and strengthening solidarity in defense.